First up, we have Matthew Liebman. He is the Director of the Litigation Program at the Animal Legal Defense Fund and works on all aspects of ALDF's civil cases. He has litigated cases including ALDF v. Otter, the first lawsuit to successfully invalidate an ag-gag law, Bennett v. McDaniel, which rescued a captive bear from a concrete cage, and ALDF v. Conyers, which resulted in the rescue of more than 100 dogs from a North Carolina hoarder. Matthew's writings have appeared in the Animal Law Review, the Journal of Animal Law, as well as the Stanford Environmental Law Journal. Next up, we have Suzanne McMillan. Suzanne is the Content Director for the ASPCA's Farmed Animal Welfare Campaign. Her work aims to improve the lives of animals raised for food by strengthening their legal protections and ensuring standards for animal welfare claims made on food packages. Suzanne received her JD from Pace Law School, where she founded a Untitled Chapter, thank you very much, and her LLM in Agriculture and Food Law from the University of Arkansas. Prior to joining the ASPCA, Suzanne served as a Farmed Animal Law Fellow with Lewis and Clark's Animal Law Clinic. And last but not least, we have George Kimbrell joining us. George is from the Center for Food Safety, where he is the legal director and he oversees all of the center's legal work. Along with his director duties, George is counsel in many of the center's cases. His legal, legislative, and policy work runs the gamut. Among other cases, George was counsel in Monsanto v. Gersten Seed Farms, the first U.S. Supreme Court case on the regulation of genetically engineered crops. He received his law degree from Lewis and Clark Law School, where he now teaches as an adjunct professor. And with that, I would like to welcome our panelists.
Right, thanks Pam, and thanks to all of you for coming. So we're going to be talking about factory farming this morning, a system that causes much more animal suffering and exploitation than any other human use of animals. Of the animals used and killed by humans in the United States, approximately 99.6% of them are farmed animals. So you could take all the animals on fur farms, on roadside zoos, in research laboratories, and puppy mills, and that's still just 4 out of 1,000 animals. So it's incredibly important that we as a movement certainly not neglect those animals, but also that we do things for farmed animals, that we focus on their suffering as well. Close to 10 billion land animals and billions more aquatic animals are killed for food in the United States every year. On average, that's about 20,000 land animals a minute. Between now and the end of this panel, 90 minutes from now, 1.7 million animals will have been slaughtered. If you're like me, it's hard to wrap your mind around those numbers. Joseph Stalin is reported to have said that 1 death is a tragedy, 1 million deaths is a statistic. But of course, each of those tens of billions of lives is a unique individual whose experience of the world has been snuffed out. And so it's our task to recognize that these almost incomprehensible statistics are really the cumulative horror of billions of individual discrete tragedies. And so with that in mind, let's look at some of the specifics of factory farming and what it entails. So factory farming is the application of industrial methods, modern technology, and ruthless efficiency to the lives of animals who are raised for meat, eggs, and dairy. One of the hallmarks, perhaps the defining feature of factory farming, is intensive confinement, where as many animals as possible are confined into a small area and managed with little regard to their well-being. Here's an example on this slide. These are gestation crates, which are the industry standard for breeding pigs who are raised for meat. They're tiny metal stalls, so small that the pigs can't even turn around. Pigs are intelligent, inquisitive animals, and being confined in concrete and metal for the entirety of their lives literally drives them insane. And so you'll see them resorting to abnormal behaviors like chewing at the bars until their mouths bleed and swaying and rocking constantly. Another form of intensive confinement that characterizes factory farming are battery cages for egg-laying hens, where each bird has less than a standard 8.5 by 11 sheet of paper to live her entire miserable life. She's so crowded into a cage that's so small that she can't even extend her arms or engage in most other natural behaviors. Numerous undercover investigations at factory farms have exposed dead and rotting birds in the cages with live birds who are laying eggs for human consumption. Another example of intensive confinement is veal crates, in which calves are confined in stalls that are so small they can't even turn around. They're also typically tethered to keep their muscles underdeveloped and their flesh tender. Veal is a byproduct of the dairy industry, where cows must remain in a constant cycle of pregnancy and lactation. And of course, the male calves, who aren't needed by the milk industry, are then sold into the veal industry. The dairy industry also directly uses forms of intensive confinement. These are calf hutches, where calves are separated from their mothers so humans can take the milk that was meant for them, and they can be raised as the next generation of dairy cows. Another aspect of factory farming, in addition to intensive confinement, is routine mutilations, things like debeaking and tail docking, but also unanesthetized castrations, horn removal, all of which are means of violently forcing animals to essentially change their anatomy, to change their biology to conform to the uses for which we'd like to use them. So the factory system describes not only the way that farmed animals live, but also the way that they die. Industrial slaughter, I think, is also a hallmark of the factory system, in which large numbers of animals are quickly slaughtered, often without adequate stunning practices, then bled dry and disassembled piece by piece in a way that evokes the assembly line in reverse. I found this on Google Images while preparing this presentation. I did a Google image search for industrial slaughterhouse. This is a Halloween attraction in Kentucky called the Industrial Slaughterhouse, 5 Years of Fear. So industrial slaughter is quite literally a house of horrors. So how do we use the legal system to fight the horror of factory farming? And there are a number of ways that we can talk about. The first, and so far the most effective, has been legislation and ballot initiatives. Since 2002, 11 states have passed laws prohibiting some of the worst forms of intensive confinement, beginning in 2002 with the Florida initiative banning gestation crates, and most recently in 2016 with the Massachusetts initiative that banned battery cages, gestation crates, and veal crates, as well as banning the in-state sale of products that were produced through those forms of intensive confinement. Perhaps the most significant development in terms of ballot initiatives was Proposition 2 in California in 2008, which passed overwhelmingly. It was sponsored by the Humane Society of the United States and many other animal rights groups that supported it. And it requires that any animal on a farm, egg-laying hens, pregnant pigs, and calves raised for veal have enough room to stand up, turn around, and extend their limbs. Unfortunately, the egg industry interpreted that to still allow cages. They created slightly bigger cages or took some birds out to create more room per bird, although it's still not enough. And so there's a new effort for 2018 to more clearly prohibit cages in California and prohibit the sale of animal products that were produced in other states using the prohibited methods: battery cages, gestation crates, and veal crates. There have also been legislative pushes to ban tail docking, which have succeeded in New York and California, and other means of challenging factory farming through the legislative process. There's also the regulatory process. Certainly there are many regulations promulgated by the USDA, FDA, and other federal agencies pursuant to the few federal animal protection laws we have. And so we can use the regulatory process to ask those agencies to create stronger protections for animals, and we can also use the regulatory process to fight back efforts by the industry to loosen those regulations. So for example, there was a recent effort by the chicken industry requesting that chicken slaughterhouses be allowed to slaughter chickens at higher speeds. Mercy for Animals drafted a letter that other organizations signed on to opposing that process. And we'll hear a lot more about the regulatory approach from Suzanne in the context of organic regulations. And the third approach is through litigation. So we can file lawsuits to stop some of the worst forms of animal abuse on factory farms. ALDF has used creative civil causes of action to challenge farrowing crates, which are similar to gestation crates, tiny metal stalls where pigs can't even turn around. And we filed a lawsuit to try to enforce a section of California's Penal Code, Section 597T, which requires that anyone who confines an animal has to provide that animal with an adequate exercise area. And obviously, a crate in which an animal can't even turn around is certainly not an adequate exercise area. And so through those kinds of creative approaches, we can use litigation to fight some of the worst forms of factory farming. We can also use litigation defensively. So as we continue to rack up victories at the legislative level, we can expect industry to challenge those, and that's exactly what they've done. There have been challenges to Proposition 2, challenges to California's foie gras ban, and so we can step in as interveners, or at least as amicus, and encourage the court to recognize the power of states to protect animal welfare. So all of these efforts are essential for reducing animal suffering in the here and now and for taming some of the worst forms and abuses of factory farming. But of course, we have to step back and ask the question, can this fouled up system be fixed? And for some of us, this factory system is so irredeemable, so inhumane, and so fundamentally unjust that we'd rather see it abolished altogether. Factory farming is not a fixable system because it rests on the flawed premise that the complexities of animal life can be regulated, managed, and exploited for the benefit of humans. And so even so-called humane producers, even cage-free farms, even family farms violate the rights of animals. If we take seriously the idea that animals are sentient beings who not only suffer and feel pain, but also are capable of positive emotions like joy, curiosity, and friendship, then we have to question the entire premise of exploiting them for their bodies. So taking their lives, even while minimizing their suffering, deprives them of something valuable, a life worth living. And I want to read just a section of, this is a book called Pleasurable Kingdom, written by Jonathan Balcombe, who we'll hear from tonight, that's about the capacity of animals to feel not only pain, but also joy. So he writes, "The behaviors, sensory abilities, and flexible lives of many of our animal kin suggest beings who are not merely alive, but who have a life. As American philosopher Tom Reagan puts it, they have not merely a biology, but a biography. They are lives experienced across the pain-pleasure continuum, lives made better or worse by their circumstances. If we recognize animals' capacity for pleasure, then we may conclude that it's wrong to deprive them of it." So even systems that reduce as much as possible the pain and suffering that's attendant to raising an animal and slaughtering him or her, that process nevertheless deprives them of the opportunity to live the rest of their lives in ways that would give them joy and companionship and community. And so we have to think of other ways of attacking the system that don't maintain it. So even humane dairy farms, to give another example, sever the connection between mothers and their calves, a bond that causes, the severance of which causes immense trauma to both the calf and the mother. This is a news story from about 4 years ago that has always stuck with me. Let me read it to you. The headline says, "Strange noises turn out to be cows missing their calves." Strange noises coming from High Road near Sunshine Dairy Farm Monday night and into yesterday morning prompted local police to alert residents that there's nothing spooky or scary going on. According to Newberry Police Sergeant Patty Fisher, the noises are coming from mother cows who are lamenting the separation from their calves. The separation of mother cows from their calves is a yearly occurrence and is a normal function of a working dairy farm, Fisher said. It happens every year at the same time, she said. Fisher said her department received at least 4 calls between midnight and 7 a.m. yesterday morning regarding inhuman-sounding noises, prompting her to post a quick message on its Facebook page yesterday. Residents in the area of Sunshine Dairy Farm may notice loud noises coming from the dairy cows at all hours of the day and night. We've been informed that the cows are not in distress and that the noises are a normal part of farming practices. Well, she's half right. They are a normal part of farming practices. But to say that a mother who's lamenting the loss of her calf or a calf who's lamenting the loss of her mother is not an animal in distress, I think that strains credulity. So even humane or efforts to make factory farming more humane deprive animals of their rights. And cage-free and free-range systems are certainly an improvement from a welfare perspective, but the birds often still come from the same commercial hatcheries as industrially raised animals. And at these hatcheries, the males, who are useless to the egg industry, are macerated or ground up alive. And of course, the growth and demand for these systems have led many producers to cut corners, and the regulatory terms are ill-defined in ways that allow abuses that most people wouldn't expect if they're buying free-range products. So in light of the fact that some of us want to recognize legal rights for farmed animals, what can we do to end factory farming, not just fix it, not just remove some of the worst abuses? Well, sadly, given the realities of hostile legislators, agencies that are captured by the industries they're supposed to regulate, and judges who are only beginning to contemplate legal rights for species like chimpanzees, we probably shouldn't expect to eliminate factory farming anytime soon directly through legislation, regulation, or litigation. But there's still so much work to be done. It's my belief that law tends to follow social change, it doesn't produce it. And so it's our job to not only fight the battles to reform factory farming, but also to use our skills as lawyers to help transform the culture by shining a light on the reality of animal agriculture. And there are a few ways that we can do that, and a few ways that we do that at the Animal Legal Defense Fund. One is to ensure that activists have the opportunity to share the story of farmed animals with the public. And we've done that through our Ag-Gag litigation. For those who aren't familiar, Ag-Gag laws are laws that criminalize undercover investigations at factory farms and slaughterhouses. Over the last decade or so, there have been more than 80 undercover investigations that have, without exception, exposed horrific animal suffering. And that's not only what you often see in terms of, a single bad apple sadistically abusing an animal. It's things that are systematic, things that are routine, and in fact, things that are inherent in animal agriculture. And these undercover investigations are absolutely essential to the ongoing public debate about the ethics of factory farming. And without these investigations, the public will be kept in the dark. And that's exactly what the industry wants. So we've filed 4 separate lawsuits challenging ag-gag laws. 9 states have them. We're making our way through them. We have successfully sued Idaho and Utah and won on summary judgment in both of those cases. Utah decided not to appeal, so that victory is final. Idaho is currently on appeal before the Ninth Circuit. In North Carolina, unfortunately, we were dismissed on procedural grounds for lack of standing. That's been fully briefed to the Fourth Circuit and will be argued later this year or early next year. And then just this week, we filed a lawsuit against Iowa, one of the largest agricultural states in the country, the leader in terms of pigs raised for meat and egg-laying hens. So we're taking the ag-gag fight to the heart of animal agriculture. Another way we can ensure that we're laying the groundwork for a culture that at some point is ready to recognize rights for farmed animals is by supporting activists. This is a photograph of a group called Los Angeles Cow Save, which holds vigils at a slaughterhouse in Los Angeles County. So they go out and stand quietly with candles and signs to educate the public about what's going on. So cars driving by know that this is not just a space, an industrial warehouse, but it's a place where animals are being killed. And the slaughterhouse obviously was not too happy about that, so they filed a trespass lawsuit against the activists. And we represented the activists alongside a couple of terrific Los Angeles attorneys, Matthew Strugar and Ryan Gordon, and filed what's called an anti-SLAPP motion. So California, like many states, has an anti-SLAPP statute, which is SLAPP stands for Strategic Lawsuit Against Public Participation, and these are lawsuits that are filed against people to retaliate for their exercise of their constitutional rights. And so to ensure that people who are exercising their right to free speech aren't tied up with the expense of litigation, the anti-SLAPP statute creates the opportunity to have that lawsuit dismissed. So we filed an anti-SLAPP motion, ALDF, with Matthew and Ryan in support of the Los Angeles Cow Save organization, and the judge granted it. The lawsuit was dismissed, and the slaughterhouse was ordered to pay almost $100,000 in attorney's fees. So by supporting activists, by making sure they have, thanks. So by supporting activists who are drawing attention to the tragedy of animal slaughter, I think we're helping to lay the groundwork as attorneys for a society that's ready to recognize farmed animals for the kinds of beings they are. A third approach that we've taken at the Animal Legal Defense Fund is through false advertising lawsuits. And as we, as a movement, tell the truth, we can expect the industry to try to obfuscate it, to co-opt our language of compassion to sell their products. So we can use false advertising law to expose the myths about animal agriculture, to remind people that animal suffering and animal devastation, environmental devastation are byproducts of the industry. This is a lawsuit we filed against a place in Petaluma near ALDF's headquarters called Judy's Family Farm. They sell organic eggs. The package, as you can see, portrays hens playing with their chicks in a nice green field. And the inside of the carton, it's probably too small to read, but it says, "These hens are raised in wide open spaces in Sonoma Valley where they are free to roam, scratch, and play." Now, the bottom right picture is a picture of Judy's family farm, 2 large barns where the animals are confined, and a purple waste lagoon. So certainly not representative of what's on the package or what's described on the inside of the carton. And so we sued them, settled, they changed their packaging, and we have similar lawsuits against other facilities that have misrepresented their treatment of animals. We're suing Hormel for its natural value line, and have sued a foie gras farm for claiming to be the humane choice. And so by doing that, I think we're able to redirect attention to force society to engage openly and honestly with the truth about factory farming and animal agriculture. So it's my hope that we can use the legal system to alleviate farmed animal suffering in the here and now through hard-fought battles in legislatures, courts, and agencies, by trying to reform some of the worst forms of animal agriculture, by going after intensive confinement and routine mutilations. But it's also my hope that we can use our skills as lawyers to support the kinds of social, political, cultural, and material changes that are necessary to empower animals to flourish, both as individuals and in their own communities, as the kinds of beings that they are. Thank you.
So hi, I'm Suzanne McMillan with the ASPCA's Farm Animal Welfare Campaign, and really excited to be here today to talk to you about the National Organic Program, which is the set of laws and regulations that govern how, among other things, how animals are raised for food products that are labeled as organic. So first, let's just set a little context. I think it's important to note that the public has very clear expectations and beliefs about what goes into raising animals for organic products. And so we hear consistently at high levels that both organic consumers and consumers of more conventional foods are under the belief that there are strict regulations around animal welfare for organic products. It's also their feeling that that should be the case. So it's not only that they're under the impression that that already is the case in the law, but that it very much should be. We know that there are certain attributes in particular that come to their minds when they imagine this welfare. One of them is outdoor access, and more specifically, there are attributes associated with that, such as having adequate space to range and having pasture and vegetation access, that they feel are very important. And concurrent with this, we've seen a real boom in organic animal products, and the percentage of the overall organic food market that's devoted to animal products specifically is rising. And so that seems to be partly because consumers are feeling comfortable and confident about what goes into creating organic animal food products. In particular, we've seen a big boom in the milk, egg, turkey, and chicken sectors for organic foods. So as you would imagine, part of what's coming with this is obviously many more animals being raised on organic farms. We've watched the numbers steadily rising. Of course, they still, compared to the vast majority of animals raised for food in the US, are quite small, but rising quickly. And along with that, we're seeing a lot more concentration in the organic food industry. And so while we're seeing numbers of animals booming, we are actually seeing fewer and fewer organic farms as we watch the organic census numbers. So that's alarming. That does indicate much more concentration on your average farm. And the other thing to mention here in terms of context is that the current organic standards actually represent the only federal standards we have for on-farm treatment of animals. I think it's often believed that we have no federal standards governing how farmed animals are treated when they're actually on-farm, as opposed to for transport or slaughter, but in fact this is the exception. And I think it's important to note that it even includes poultry, which, as we know, is not the case right now with our federal laws governing transport and slaughter for some species. So in some ways, the organic standards are sort of filling in some of the gaps that aren't addressed on other levels. So where are the rules situated? Well, the USDA has its Agricultural Marketing Service, AMS, and within that is the National Organic Program, and that's the program tasked with promulgating the regulations that follow from the federal statute, which is the Organic Foods Production Act of 1990. And that statute covers a number of issues. I've highlighted here just the ones that I think are most relevant to this conversation. Oh, and I should note that there's a lot of detail on some of these slides, but I'll make these available afterwards, so don't feel like you need to keep up with everything written here. But the OFPA statute touches on animal welfare, and we'll go through each of these in detail next. But animal welfare, it also creates an advisory structure for the USDA as it's promulgating its regulations. It puts in checks and balances, partly by requiring public input. It creates a certification framework for the National Organic Program, and then it has enforcement sections around compliance and appeals. So taking those one by one, the animal welfare section of the statute, in terms of the statutory language itself, it actually is quite brief and really limited to essentially chemical input. So in other words, what's in the feed that the animals are eating? Are they given antibiotics? Are vaccines okay? But importantly, the statute place marks the need to develop further provisions around animal welfare, and it does that by delegating that work to the USDA. And so there is the need, it recognizes, to identify ways to provide for the care of livestock. And so the advisory structure I mentioned is the way that this gets done. So the statute creates the National Organic Standards Board, which is comprised of 15 people who represent a variety of slots from different sectors. And they are tasked with taking public input and ultimately creating formal recommendations that go up to the USDA, which hopefully will help guide it in promulgating regulations. And as I mentioned, the statute envisions all of this, the entire National Organic Program, being structured as a third-party certification program. And so that means that you essentially have a firewall between the USDA itself and then third-party accredited certifiers, who are the certifying agents who go on farm and actually take a look at what's happening at least once a year and review paperwork for any farm applying to become certified organic or to be recertified, and either accept that application and grant certification or not. And the statute also requires public input. And so, as I mentioned, the NOSB, the National Organic Standards Board, takes public input twice a year. They have public meetings, and actually our next one is coming up at the end of this month. It'll be in Jacksonville, Florida, and I'll be there giving testimony. The ASPCA always shows up and gives testimony on behalf of animals. And the other way that public input happens is directly to the USDA through notice and comment public periods. And then there is an enforcement aspect to the statute. So essentially, a certificate can be revoked or suspended from a producer who's found to not be following the regulations, or it may be denied altogether and never issued by the certifying agent if the producer or handler seeking certification is found to not be meeting adequate standards. And so then there's an appeal process that can be pursued internally within USDA, which triggers a formal administrative proceeding. And ultimately, if the result of that is contested, that can be appealed up to the US District Court. So these are the regulations we currently have in place for animal welfare within the National Organic Program. I've highlighted for you the sections that are key, and in particular, the last three there. So the livestock healthcare practice standard, the living conditions section, and then what we call the pasture rule, which is the pasture practice standard. And that one applies to ruminants and says that ruminants in particular need a certain amount of time out on pasture per grazing season, and they should be receiving a certain amount of their nutrients through forage. So this is how obviously this is somewhat subjective, but this is my interpretation of how these regulations actually work out in terms of benefits for animals. So I've given you kind of a quick color-coded key here. I would argue that green represents provisions that at least on their face, on paper, are meaningfully important for animal welfare. Yellow represents provisions that either are too vague to be meaningful, or else they're clear and explicit, but they don't go far enough with what they're actually requiring. And then red indicates that these issues have been altogether ignored or forgotten by the program. They're simply not addressed at all in the regs. And so you can see quickly here that we're not dealing with a great framework. There's a lot of room for improvement. There's really only one area I would code as being in a pretty good place in terms of on its face what the regs say, and that's the fact that all animals are meant to have outdoor access on a regular basis. And so how does this play out in the field? Well, I'm happy to at least be able to report that most organic farms either comply with or many times vastly exceed the regulations as they're currently written. And so we do see the vast majority of producers arguing for the importance of keeping the rules strong and having true outdoor access for animals and things along those lines. However, there are areas where there are really troublesome problems, and the OIG issued a report in 2010 following an audit of the National Organic Program in which they found that the regulations, particularly around outdoor access, and especially for poultry, are so vague that they're actually being interpreted in vastly different ways by different certifying agents. And they gave an example in the report of one case where an agent had certified a farm that was only offering 300 square feet for 15,000 chickens outdoors. So that's vastly different from a situation where you have a farm offering, rolling pastures. And so as a result of that report, the OIG recommended that the NOP go back and clarify some of those areas of vagueness. And unfortunately, what we've seen is that while most producers, as I said, are already providing what you would expect from the spirit of the regs, we do have a few, and it's a growing number, and they tend to be large scale, so they're producing a disproportionate number of animals and animal products who are taking advantage of these loopholes. And so the USDA itself issued this slide probably about a year ago now, acknowledging this growing problem in the organic space, that we have essentially two different sets of rules going on. We have the folks who are complying with the spirit of organic and actually allowing their birds outside on pasture, and that's the photo that USDA provided here in the lower left. And then you have a photo on the upper right, which is what's called a porch system, and that's increasingly what we're seeing from organic egg producers. They're claiming that this constitutes outdoor access, to allow birds to be on a solid floored porch. Sometimes it's elevated like what you see here, other times it'll be on the ground level, but solid floor and generally with a roof and with screening around it, which is really the only aspect of it that involves the outdoors. So that obviously precludes the birds from accessing soil or vegetation or anything along those lines. And the NOSB's public hearings that it holds every 6 months often invite testimony about how the rules should be addressed and strengthened to try to preclude some of these problems. And these are the sorts of testimony we're seeing from producers who are arguing that they should not have to provide true outdoor access and that porches are sufficient. So I've just pulled out a few quotes here from transcripts, and these are all public. You can find these online. But we hear things like, the proposed outside space of 1.8 square foot per bird, I cannot comply. I just do not have additional outside space available. And so here are just a couple quick case studies I wanted to highlight of how this has been playing out. The first is the Country Hen case. Country Hen is a Massachusetts organic egg company. And in 2002, they applied to a certifying agent to try to get certified organic. And they had, at the time, no outdoor access for their birds. They had plans to add porches to their facilities, and they argued that that should be enough to constitute outdoor access. At the time, no one had really seen the porch model before. It was not anything that had showed up in the organic space. And the certifier turned them down and said it was not sufficient. So then they applied to another certifier because the way as I mentioned, this is structured as a third-party certification program. That means that it's a fee-for-service arrangement, and so farms can essentially shop around and contact and recruit whichever certifying agent they would like to invite to check out their facility. And so in this case, they were turned down by the first. They went to the second. The second one also turned them down. And so they then appealed directly to the USDA, and USDA overturned the certifying agent's decision and granted certification status. At this point, the agent appealed to USDA themselves and argued that that was inappropriate. And went through two different departments in USDA, ultimately denied in 2004, so they then appealed up to the federal court. And in 2007, the case was dismissed. The court found that the regs are valid in terms of USDA being able to override a certifying agent's determination that a farm is not in compliance and should not be granted certification status. The more recent case I wanted to highlight, because this has just been in the news in the last few weeks, is the Aurora Dairy case. So Aurora Dairy is essentially a mega dairy company, and this case has revolved around a particular facility in Aurora, Colorado, which has about 20,000 cows. I believe about 15,000 of them are milked at any given time. And the Cornucopia Institute had been investigating this farm and had gone and taken footage that seemed to indicate that very few cows are out on pasture even during the grazing season when, as I mentioned, under the pasture rule for ruminants, they should be out on pasture quite a bit. And so they had actually filed a formal illegal complaint with USDA about this. And the Washington Post picked up the story, and they did their own investigation and took additional footage and came to the same conclusion that very few of the cows were actually out on pasture when they should be during the summer months. And so ultimately, the USDA actually just issued its decision last month, clearing the farm of any violations and maintaining that it is in fact meeting certification standards, even while acknowledging that the certifying agent had been visiting the farm during cold months, I believe in November, when you wouldn't expect the cows to be on pasture, and so they had no way to know whether the cows were being grazed when they should, and USDA acknowledged that that was a violation of its rules. So as a result of all of this confusion and controversy and these expanding loopholes, there's been a long-standing effort on the part of many of us to revamp the regulations altogether and essentially start from scratch and just have a new framework put in place that is comprehensive and makes explicitly clear animal welfare. And so, let me just go back. And so what we have been able to get out of that is the Organic Livestock and Poultry Practices Final Rule. That was issued by the USDA in the final days of Obama's administration, and it was really heralded as a massive leap forward for animal welfare. And this is what it does. I've highlighted some of the key outtakes. There's way too much to cover, but I just want to be sure to highlight some of the exciting outcomes that for the first time it separates out poultry standards, acknowledging that poultry are their own species separate from the mammalian species, and so because of that they have their own needs that are quite different, and so it goes into explicit detail there around what they need. It also for the first time adds transport and slaughter standards. It's explicit about what outdoors actually means, that it means contact with soil and vegetation, with the exception of pigs, who unfortunately were trying to work through that, and they didn't go quite far enough for pigs, but for all other species it's very clear. It also details enrichment requirements like perches and bedding. It's explicit about the ways that animals actually access the outdoor space, so that it's not enough to have a nice outdoor space, but they have to be able to get out there easily from their indoor areas. It severely restricts certain forms of physical mutilations that are currently fine under the organic program, like debeaking and tail docking, and it has pain control provisions for situations where there would be pain inflicted on an animal or illness causing suffering. So it goes much further. It also details actual dimensions and metrics for space for poultry, indoors and outdoors. So, not perfect. Certainly there are areas we already have our eye on to try to shore up, but much, much better than the framework we've had so far. So as I mentioned, this was really heralded and celebrated, and then our bubble was burst as the Trump administration took over, and because the rule at that point had been finalized, but its implementation date had yet to take effect. It still had a few months. And so during that interim period is when the new administration took over, and unfortunately one of the first things they did was freeze the rule. And so they delayed the implementation date by a few months. And then as that new date was coming up, they froze it again. They delayed it again. And it now has a new implementation date of November 14th, so coming up here in just a few weeks. Unfortunately, at the same time that they issued the second delay, they also issued a new proposed rule. And that was fairly unprecedented in the way it was presented. It was essentially a poll of the public asking what we all think they should do with the rule. And they offered 4 options. The first was to go ahead and implement the rule on schedule. The second was to delay the implementation. The third was to suspend indefinitely. And the fourth was to just withdraw the rule altogether. So as a result of this logjam we're currently in, the ASPCA and many other groups have formed a really broad and deep coalition fighting tooth and nail to get this rule implemented. So we have a strong coalition that's come together around farmer voices, farming groups, the corporate sector, NGOs representing pretty much every sector you can imagine. And so we've been lobbying USDA, lobbying representatives on the Hill, trying to get as much media coverage as we can on this issue, essentially generating pressure on USDA to go ahead and implement. And so these are the legal fronts we're dealing with right now. There's a constant threat of appropriations being used to defund or reduce funding for implementation of the rule on the Hill. This has come up a few times already this year. We've been able to successfully beat back all these attempts, but it's something we continue to keep our eye on. Unfortunately, we're heading into a Farm Bill year in 2018. That's a major vehicle to potentially disrupt implementation of the rule, and so we're keeping our eye on various ways that that could happen. On the regulatory side, obviously USDA itself right now is the main impediment. They have the power in their hands to implement the rule any day they see fit and just are refusing to do it. So there's a lot of pressure directly on them, and we actually just released a report a few months ago along with a few other groups shaming USDA and really sort of exposing all the details that have led up to the situation we're now in. And the need for them to go ahead and implement. And to that end, I'll also mention the NOSB, which, if you remember, is the advisory body to USDA, took an unprecedented step at the last public meeting about 6 months ago, where they issued a unanimous resolution shaming USDA for freezing this rule and calling on them to implement it. And then there is a litigation front now. As of just a few weeks ago, the Organic Trade Association filed suit against USDA for delaying this rule, and they're claiming violations of the APA as well as the underlying statute, the Organic Food Production Act. And so I would just ask everybody to join us in trying to get this rule implemented. As I mentioned, the new implementation date is November 14th, so it's looming over us. And we have the new proposed rule from USDA also potentially conflicting with that, so there's a lot at play. And now with this lawsuit filed, it will be very interesting to see what happens next. So as I've mentioned, we've put together a coalition that's fighting to get this done, and I would invite any of you to please reach out to me if you have ideas for other things we can do to strengthen our coalition, or let me know if you're aware of folks who might be helpful to our case. And I've included on here a link to our website, our webpage specifically, where we have information about this situation, and there is a little link on there that you can follow to sign up to get alerts from us so that we could alert you when we need representation on the Hill, or reaching out to USDA, which actually I would say you could do really any day now, any minute. You don't have to wait on that. Secretary Perdue would love to hear from everybody about this. So yeah, thank you for your time. I appreciate it.
Thank you for being here with us, and thank you for the conference for inviting me to be a part of the distinguished panel. I'm George Kimbrell, and I'm the legal director for the Center for Food Safety. I run our Pacific Northwest office here in Portland, Oregon. If you don't know us, Center for Food Safety is a nationwide nonprofit 501c3 public interest organization. We have over 900,000 members across the country, farmers, consumers. And our mission is to address the adverse impacts of industrial agriculture and promote and protect more sustainable alternatives. And we do that by empowering people, supporting farmers, and protecting the environment. You might be wondering what the food safety guy is doing here at the Animal Law Conference. And so I'll say a few words about that, and then kind of go into what I hope to cover in my time. What we mean by food safety is more, yes, some of my work deals with what would be traditionally considered stopping foodborne illness and pathogens and things of that nature, nutrition standards, labeling, but we mean it in a much more holistic sense. We mean food that's safe not just for people, but for the environment, for trees, for bees, for rivers, and yes, safe for animals as well. So for us, in our work, this is the way that we approach the food system. And we do that through a number of program areas, all that are related to the topics here today. I've highlighted and bolded 3 of the most specific ones, but I also want to emphasize that, as I do to my class at the law school, that the food system is our most intimate connection to the environment. And so, when I teach food, agriculture, and environmental law, it's an environmental law class. It's a food law class. It's all of these things all at once. So the most intimate and direct relationship is the fact that animal welfare and food safety are intrinsically intertwined. Sick animals make sick food, first and foremost. So the issue of having, as Matthew eloquently described and showed on his powerful slides, crowded industrial facilities create unsafe food for all of us. And the other issue is, the right to choose a different food future for ourselves, for future generations. So it's both trying to address the harms of this industrial paradigm that we have now, but also creating transparency in this system and promoting other options so people have a choice the way that they feed themselves and their families to support other systems. So, I'm going to go over a little bit, first, some of our litigation having to do with animal factories in several different areas. And in particular, I'm not going to cover all of our cases, but I'm going to kind of try to hit the highlights of some of our newer cases. That'll be first, dealing with kind of food additives, pollution aspects of the environment, and then mislabeling. And then at the end, I'm going to try to cover what I think is one of the newest fronts in animal factory, newest battlegrounds, and because the conference is covering it some, which is industrial aquaculture. So it happens I have a few new cases dealing with industrial aquaculture. This is a new program we've had for a few years now, so I'll cover a little bit about that as well. But let me say that, there you can see we do quite a lot of programs, and in those programs we do not just litigation, but policy, as Matthew was saying, a lot of legislation, a lot of work having to do ballot initiatives, things of that nature, a lot of coalition work. I mean, one of the most powerful things about this particular movement is that we are doing a lot of work now more effectively in collaboration and coalition. Center for Food Safety was one of the founders of the Animal Agriculture Reform Collaborative, which is this kind of system-wide collaborative between animal rights groups, consumer groups, environmental groups, all of us working together to try to be coordinated and most effective as we can to address the harms of this system and put forth what we think are better alternatives to it to the extent that's possible. So I will say, you look down there, for me personally, I do a lot of work on both sides of the equation. I think one thing to remember is that on the crop side of things, the industrial monoculture system that we have, that's one of the major drivers. So I do work on genetically engineered organisms, on pesticides, all of those things that most of that, those cornfields, those soy fields, they go to support this industrialized meat system that we have. Without that industrialized monoculture system, you're not going. It's the sine qua non. I mean, it is the irreducible minimum that they need, along with the drugs and everything else that goes into that system. So, again, intrinsically entwined. Okay. So, in our Animal Factories program, I think we have 3 different foci. One on the animal drug side, I'm going to talk a little bit about that. That is the inputs that go into this system, 2, the pollution that it causes to our environment, and 3, kind of transparency in the system, giving people a choice in their food systems. So starting first with the pollution side of things, one of our newest cases that we filed earlier this year is the Big Island Dairy case. This is a case out in federal court in the District of Hawaii. It's a clean water enforcement case, and I think it's a good example because it's kind of a very typical microcosm type case of how you can use a tool like the Clean Water Act to address some of the harms of these animal factories. This is a case about a mega dairy that has about 3,000 cows there on the Big Island of Hawaii. Their packaging and their labeling says things like fresh, local milk, and it has a kind of a red barn and a green field, all the normal cliches that you would see. The reality is it's owned by several out-of-state Idahoans who also own a mega dairy in Idaho. And the reality is that the cows there are kept entirely in indoor facilities, not on green pasture. The pollution aspects, generally speaking, and specific to this mega dairy, are significant. You're talking about thousands of animals confined in one particular place, poisoning water, releasing hazardous air pollutants, damaging soil, local communities' drinking water, and causing respiratory distress in general. So the upstream impacts of this include, as I was saying before, all the monoculture of grains and pharmaceutical production that goes into it. The downstream impacts include environmental pollution, foodborne illness, loss of family farms, wildlife destruction, and of course, inhumane treatment of animals. In the case, we represent a local community group from the town that is directly downstream from this facility. And the case was filed in June 2017. It's based on 5 years of Clean Water Act violations in which they've been discharging into the local waters without a Clean Water Act permit of any kind or any restrictions on those dischargings. Obviously, with these types of facilities, this waste is supposed to be reused and contained within the facility. In reality, what happens with these facilities is that's impossible because they are inherently unsustainable production methods that by their nature cause harm to the environment, to animals. So what happens, how does the pollution get out and into the environment? Through improper application, non-agronomic or non-farming used application of the feces and the urine, the manure, the animal waste onto the fields that then runs off into the local waterways by the fact that they store it in giant lagoons that are not lined with synthetic liners, but rather are earthen and inherently leak into the groundwater and hydraulically connected to the drinking and service water. Through overflow from those lagoons, seepage into local streams, and leakage from water troughs that carry this waste into local streams. So this particular facility has millions of gallons of these animal feces and urine that then, if not properly handled and treated, become a significant public health and environmental risk. This case has just begun. We've just started discovery. We have a site visit upcoming next month. And I think it's fairly typical of these types of ways of using the Clean Water Act to try to better regulate them and get a handle on their practices, and eventually, stop them, try to reform them. So a lot of the work, and I'll get to this kind of at the end, is trench warfare, little by little, using the best tools we have. That, of course, were never intended to regulate these types of industrial 21st century food system problems. So you're squeezing blood from statutory stones. To extent that our job as attorneys is to try to use the law as a tool the best we can to address these problems. But until and unless we get better, more progressive laws, which in these Trumpian times is a far cry to imagine, we use what we have. And here we use these fundamental 50-year-old environmental laws like the Clean Water Act. So this is the local stream down from the dairy. You can see there our clients took these photos, tested this water that reeked of feces, and it tested, in fact, to be contaminated with E. coli and other bacteria. So there is a classic example of this type of a runoff from these mega dairies, these animal factories. The other cases I wanted to mention in this world, one case in which we were a client, a big challenge to the Washington State General Clean Water Act permit here. And this is an important case because it's an opportunity to get a good statewide Clean Water Act permit for all of these CAFOs in the state of Washington, and more broadly, as an example, as an improvement on this system nationally. So the reason we're involved and others are involved in it is because we think it has a chance to become the gold standard as far as improving permits, getting things like synthetic liners on these lagoons, getting limits on the waste output agronomically, and on what can be contained in that waste output. And so, unfortunately, the permit was not as good as we were hoping, so we've challenged it, but we have entered into settlement negotiations with the state and the industry interveners, which are ongoing right now. And the reason we think we have good leverage there is because of an earlier case in which Center for Food Safety was both a plaintiff as well as co-counsel, a very important coalition case here also in the Pacific Northwest in Yakima Valley, the Cow Palace case, the Bosma case, that settled in 2015 after a district court summary judgment victory in which, for the first time, a court ruled that a hazardous waste pollution statute, Resource Conservation Recovery Act, applied to farm animals, applied to these types of facilities, and said that the application of manure in this way was improper and was waste under that statute. So that led to this consent decree that did establish these limits on those particular mega dairies there in Yakima Valley that were contaminating the local community's drinking water. They had to double line, synthetic line their lagoons. They had to monitor the groundwater going forward. They had to limit the amount of the manure and other pollution impacts of their facilities. So the idea with the general permit challenge is to try to have that be the new floor for the state permit in Washington and as an example for the country. Matthew mentioned the Ag-Gag cases. I mean, I won't get into them. They're listed there. The newest one was just filed earlier this week in Iowa. They're massively important cases. Again, huge coalitions led by ALDIF and others, to preserve our constitutional rights and freedoms and provide transparency into this system. So I think picture is worth 1,000 words is the cliche here. I think, whether it's through labeling or other methods, trying to get that transparency in the system and give people choices and let them know what the realities are of where their food comes from, makes a massive difference. So these constitutional cases, I think, are incredibly important. Hopefully we're going to get a win from the Ninth Circuit in the one that's pending on the Idaho challenge where we won below. I think that's the leading, most important decision we're waiting for any day now at this point. So. Animal drugs. So I talked about monoculture and grains as one prop to the system. I think this is one of the other major props to it. You can't have these animal factories without the reliance on the rampant use of animal drugs and feed additives to produce their rapid weight gains they need and to suppress the negative health effects. So I think most people know about antibiotics, antibiotic resistance, the fact that we use over 80% of our human antibiotics for non-therapeutic reasons in these animal factories. Obviously, that's a huge concern for many correctly, that we need to reform using all the levers that we can in federal government and state, and CFS and others are working to do that. But there are a lot of other very terrible animal drugs that go into these systems to prop them up that have terrible impacts on the animals themselves, such as ractopamine, a non-therapeutic beta agonist drug, which has been banned in the European Union, China, and Russia. So, one of the aspects of our program at Center for Food Safety then is to try to address these inputs into this system. So the case I wanted to mention here is a precedential case dealing with trying to do that, a case where we filed against the Food and Drug Administration, which approves animal drugs for use in these systems. It's under the National Environmental Policy Act. So our charter for addressing environmental impacts, including impacts to animals, but also runoff from these systems. And ractopamine, under FDA's own analyses, causes the most harm of any of these drugs to animals, more than any other animal drug currently on the market. So the case dealt with trying to address 18 different ractopamine drug approvals. Of course, there's about 450 overall animal drugs that FDA has approved in these systems. So again, a microcosm of a much larger problem, and trying to use legal tools that we have, such as NEPA, to handle them. The problem is that FDA has no transparency. It's a drug approval process, just like human drugs, but for animal drugs. So there's no notice and comment. We don't know what the analysis or assessment the agency has done until the final decision is given out. And what's happened in the case so far is basically that the district court first on a motion to dismiss, and now the Ninth Circuit more recently in a memorandum decision issued not too long ago, have said, well, you have to give the agency a chance to address this in the first instance, so you plaintiffs have to file a citizen rulemaking petition with the agency first before you can go to court and challenge this, notwithstanding the fact that these drug approvals are final agency actions that should be challengeable in their own right. So this has been discouraging as far as the outcome of this case, although last week we filed a petition to rehear that decision en banc to the Ninth Circuit. If we lose that petition, we would go back down to the district court and either decide to file this petition while the case was stayed and let the agency try to address these issues, or find a new legal avenue to try to address this animal drug problem. I should say that this is, again, a coalition case, like much of this work, where we're counsel, the Humane Society of the United States is counsel. We represent Aldif Center for Biological Diversity, United Farm Workers, lots of groups that are working together on this issue. So we'll see, to be continued, what happens there, but I think this is an important aspect of the system that is going unaddressed, where, again, trench warfare, we're trying to improve things. So then the last part of this animal factories work, similar to what Matthew was saying, is kind of the false advertising side of it. We have a new case we filed earlier this year, the Sanderson case. This is with the Richmond Law Group. We're co-counsel with them in this case. We represent some other nonprofits as well, Organic Consumers Association. It's a case, Sanderson, it's a Mississippi-based company, $3 billion a year chicken company. They sell their chicken in Olive Garden, Arby's, Albertsons, major producer. They label their chicken 100% natural. They have these really outrageous videos on their website about their practices. If you want to have a tragic laugh, I Googled them. But the USDA itself, the FSIS, did some testing of this chicken, and it turned out that it had a ton of residues, antibiotics, hormones, human drug residues on the chicken that are obviously unnatural. But in addition to that, several of the drugs that were found on the chicken are actually prohibited from being on human food. So this is a case. It's a false advertising case about this chicken product not actually being natural. But it's also a case, like much of our docket, to raise awareness, have a precedential impact and address a harm, but also to have extra legal impact as far as addressing the fact that natural has no meaning. Consumers are misled by it. as opposed to organic, for example, which has its problems, but at least has a federal definition. Natural really means whatever people think they can get away with putting on a package, and it's unfortunately left to litigation to be the backdoor regulation of that harm. So that's our Sanderson case earlier this year, just getting started now with discovery in that case. Okay, so water CAFOs. Industrial aquaculture, this has been going on in the world more broadly for quite some time now. The U.S. is a latecomer to it. We have this kind of negative, we import a lot of the seafood problem, and I think there are industrial interests in this country that really want to get into this. And so for about a decade now, we've seen bills introduced in Congress and other pushes to try to have a federal scheme set up to do industrial aquaculture in U.S. Waters, the exclusive economic zone, for example. I think just like animal factories for cows, chickens, poultry, the way that aquaculture is done at a commercial level right now, in the main, finfish aquaculture, shellfish aquaculture, is inherently unsustainable. It's a problem of scale. It's a problem of pollution. Are there ways to do aquaculture that could be sustainable? Well, there's tilapia, for example, or herbivorous fish that potentially wouldn't have the impacts that a lot of these facilities have as to the overuse of, forage fish and forage fisheries in order to feed them, because you have a negative protein ratio for growing these large carnivorous fish that they want to grow, salmon, tuna, and so forth. You're going to have the same problems with crowding and disease that you see in the animal on-land CAFOs, requiring dumping in of chemicals, pesticides, fungicides, other fumigants, anti-fumigants to try to address those harms. And of course, from the animal, perspective, you're going to have the problem of the natural behaviors of these animals and how you have a heroic species like the salmon, an anadromous species that would swim 10,000 miles in its life journey that's going to be confined in this facility for its lifetime. So here's a good slide that has some examples of the harms to the environment and so forth. You've got all of the feed issues coming in, you've got the drugs coming in, you have the escapes that go out that harm biodiversity into our wild fisheries, you have the wastes that go out that harm our ocean ecosystems, you have diseases and parasites that are spread to other species. So 3 cases I've got right now on this. The first one I kind of mentioned before, this is down in New Orleans in the Eastern District of Louisiana. We just started summary judgment briefing on it, filed our opening brief last month. This is the test case to see if they're going to do industrial aquaculture in the EEZ, the exclusive economic zone. In this case, I represent environmental groups, I represent commercial and recreational fishing groups, and we have arguments under NEPA, the Endangered Species Act, but most importantly, we're arguing that the Department of Commerce attempt to grow aquaculture under the Magnuson-Stevens Act is ultra-virus. That is, they don't have the authority to do this under this law, because aquaculture is different than fishing, which is what their authority is under Magnuson. The second is a case of my colleague who's here with us, Amy Von Sant, who is a staff attorney in my Portland office, that she's developed over several years, that I think is one of the most important cases, the biggest case dealing with addressing the impacts of industrial shellfish aquaculture. Washington State is kind of the ground zero for that. It's a $100 million industry on the coast of Washington in Puget Sound and Willapa Bay. You're talking about a lot of pesticide impacts there. You're talking about plastics. You're talking about netting and monocropping of 1/3 of the Washington coastline here, and the harms to biodiversity from that. So it's a Clean Water Act, NEPA, Endangered Species Act case. And then finally, our case challenging the unprecedented approval of the first genetically engineered animal for food, which is a genetically engineered salmon, which has been going on for a couple of years now, that obviously would be grown in aquaculture facilities. To follow up on the issue of organic, I would say, in addition to the animal welfare fight, that is a hugely important one that you should definitely be engaged in, the next battleground I see in organic is aquaculture. For a long time, the NOSB, the National Organic Standards Board, has been struggling with how to define and whether to have standards for organic aquaculture. And so we haven't seen a rule yet, although prior to the Obama people going out and the Trump people coming in, there was one that was going to be proposed. It hasn't seen the light of day in the Trump administration. If it does, I think it will set up this very strange dichotomy where you have wild fishery issues. You're going to have an organic label on seafood in the grocery store for the first time, causing a lot of confusion for consumers. I think that having organic aquaculture the way that it's currently done would be, contrary to organic standards, because it's an unsustainable practice. You're going to have these problems. I mentioned a few there. How do you accommodate the health and natural behaviors of animals as the standards require? How do you deal with the fact that you're going to use wild fish for the feed when organic standards require to use 100% certified organic feed? What are you going to do, certify the whole Pacific Ocean? And then, you're going to have this problem of how do you promote ecological balance and conserve biodiversity, which organic standards are supposed to do. So this is what we do. This is where the need is. I think the litigation, the purpose of it is to try to put a tourniquet on the harm we see. I mean, at Center for Food Safety, we have a mantra every day. We stop the bleeding, and we try to shift the consciousness. I disagree slightly with Matthew as to litigation. I think it can actually jumpstart socioeconomic and cultural shifts in the way people think about a topic. So, those are some of the tools, but of course, we use all the tools we have in the toolkit: citizens engagement, rulemaking, consumer campaigns as well. So, thank you for having me be part of the panel.
Thank you very much to our panelists. And we have a couple minutes now for questions. We have 2 standing microphones right here on each side of the room if people would like to make a line and ask questions. We're also live streaming the event, so I would encourage the people watching us via live streaming to also submit some questions. Oh, okay. All right, so I think I'll let you all decide who wants to answer these questions. The first one is, are synthetic lagoon liners required by federal or state regulations?
No, not yet. That's the idea, is to try, hopefully, the Washington permit that would be federal law and Water Act as applied through the state law that runs the program there, like many states, for the first time. That would then require that and become a better fluoride or standard for lining lagoons. Almost all of them are urban line now, which inherently.
Okay. Would you like to go ahead and ask a question?
Sure. I'm kind of wondering generally how you all respond to people who, or at least I've seen people who who have worked on farms, say, like counter examples of animal cruelty on farms and say, like, this is just fake, like this is just militant vegan propaganda. This isn't real, this isn't how we treat animals. Don't say anything about this unless you've worked on a farm. We have to treat animals properly or else we're not gonna make any money off of them. I'm wondering if you guys have had those kind of responses and how you respond to them.
Sure, I'll take that one. So yeah, I mean, it's been a common industry claim that the videos from undercover investigations were staged by a doctor, and there's never been invited them many times to substantiate that, and it's never been done. So, as I mentioned, there have been more than 80 undercover investigations, and every single one shows horrific animal suffering, and the videos don't lie. And so, that's why one of the reasons that I think it's important when these videos come out to not just focus on, the individual worker who's doing the cow, but focus on the system. Because it's undeniable that battery cages are pervasive throughout the industry, and they cause a lot of suffering. The same is true for gestation periods. So that, I don't think anyone would deny that those systems were used in the undercover investigation. I think that was true. Yeah, and so the idea that they don't intentionally harm their animals because that would hurt their profits. I think that's the nature of factory farming, is volume. And if you raise enough animals, even if they're sick or less healthy, it can still be profitable even if the animals aren't well.
Would you like to go ahead and ask a question over there?
Sure.
Thank you for all of your work. My question is, how are you dealing with the economic side of it all from both the manufacturers who are arguing that what, the improvements that we are asking for will cost them in how they produce and work, and then the other side of it, the consumers who, when welfare standards and other things come up to a higher level, the cost of food will and should be a little more expensive. And how do we deal with that in a country that is dealing with just incredible social and economic injustice and disparities? So how are you guys facing all of those issues, the economics?
Sure. Well, I'll address this more from the organic angle. The economic impact of the organic rule has been very much under scrutiny, and if you remember, I mentioned that the rule was initially first delayed by the Trump administration, and that was because it had been deemed economically significant. And so USDA has put together a really extensive analysis of what that would look like in terms of shifting the rules and what that would actually cost. But what we know under organic is that it's a voluntary program on the part of producers, and it's a way for them to tap into essentially a value-added marketplace that gives cues to the consumer through labeling that this is a value-added product that's worth paying more for. And we know that consumers are just gobbling up these products, and there's increasing demand for them. So I think organic maybe is in a little bit of a separate, situated differently, and I think that's because in addition to animal welfare, there are attributes that folks associate with organic in their minds around health and environmental benefits. And so to date, we've seen that actually consumers are highly motivated to be buying these products at a higher, sometimes significantly higher price point.
Thank you. Would you like to ask a question?
Yeah, just as a question. As an Oregon attorney in private practice for a long time, I do a lot of consumer rights law, and it occurred to me from the first speaker, sort of a very effective grassroots approach might be, since Oregon has the Unlawful Trade Practices Act, which is very powerful and only has a negligence standard by the defendant, the business, that one could simply buy, for the false advertising angle, a product that's misrepresented, spend $5 for a breast of chicken or whatever, and then you've got standing where an attribute of the advertising is false, and you could sue for minimum statutory damages under the Unlawful Trade Practices Act. And so you've got court costs and minimum statutory damages, not a whole lot of money, but if a lot of people did that, I'm just wondering if I started doing that or have clients starting doing that, what the opinion of the national organizations would be if they see this sort of groundswell of small litigation where you're suing because the representations that were important to you on a $5 purchase were sufficient enough to trigger the minimum statutory damages, attorney fees, and court costs.
I think it's a great idea, and I think we should do it. We've done it in California, but yeah, we just don't have the staff to go after every single misleading product. So to see, attorneys in private practice representing clients, and having a financial incentive to do that would be fantastic.
Okay, well, I know the minimum statutory damages in Oregon are $200, attorney fees and court costs, and I know there's an ORAP case where you cannot sue for attorney fees if you're doing it yourself and you're the plaintiff, but if you got another attorney to cover for you, then that might be a lot bigger deal than the $200. But if a bunch of those cases came up, ADLF or anybody like that wouldn't feel like what's going on or anything like that.
Yeah, and I think if companies took more seriously the idea of being potentially liable for their packaging, they would be more risk averse in terms of what they put on there.
It seems a little more effective than signing a ballot measure petition. So, thanks.
Thank you.
Thank you.
Thanks to all the speakers. George, you started by asking sort of why food safety at an animal law conference, but from a public consciousness perspective, food safety is one of the most effective, most important issues on the table, the polling data shows, and so it's an incredibly important topic. I think most often the problem I see in the white papers and the conversations that activist organizations like ours and like ASPCA have is that there's there's often not this sort of straight line scientific connection between the ick factor of pink slime or antibiotics in the, being fed subtherapeutically to the animals, and then actually, specific discrete human health issues. So I was fascinated to hear about the actual drug residues on the food, and I sort of have a couple questions there that I think would be useful to hear from Suzanne as well. First of all, how widespread is that? Second, aside from legal violations, is it from a health perspective, human health perspective, simply kind of another ick factor thing, or are there studies showing actual harm? And then third, if these are true, is this an underutilized topic or issue for the animal movement when it comes to educating consumers and getting them animated on these issues?
Yeah, no, I don't think that that the Sanderson situation is singular. I think it's rampant in the industry, and that there are other cases that are going to follow this case that are similar. I think, as you alluded to, one of the biggest problems we have in general with the food system is the lack of transparency, the secrecy, the lack of data, the lack of independent testing and study, and that's attributable to the powerful industry. It's attributable to the fact that our laws are set up in a way that is intimidated and lacking in public process when it comes to things like animal drug approvals, for example, or then you have a powerful industry that are enacting state laws that we're now successfully challenging to further decrease any transparency, into the system. So it's a little bit of the chicken and the egg cliche problem. Without the data, you lack the opportunity. That's often the case in environmental litigation or health litigation in this context. So I think, to the extent you have data, then, you're empowered. The problem is, it's kind of like, I have a 11-year-old, and, we do a lot of the kid stories, and it's kind of the who's going to build a cat, all the mice are standing around. And they say, it'd be great if somebody could put a bell on the cat, then we would know when it was coming and when it was going to eat us. And I'm like, that's great. Okay, now who's going to do it? Without the data, you can't win the cases in a lot of the instances. So that's the question: how do we get it? I think we get it from NEPA. That's what they're actively cases about. And we get it through improving laws, FOIA, other things like that, and independent testing to the extent we can do it for these residues, for example.
Thank you. Go ahead. Would you like to ask a question?
Yeah. So a lot of the times, it's very easy to go after large corporations, but I come from a state where a lot of small towns, their entire economy depends on these factories. How do you work to become involved in these people who are facing socioeconomic, ramifications for it? I mean, they're worried about feeding their children, and you come into town and you're worried about the chickens, and so it's very easy to ignore that aspect of how you're affecting, that area. So I'm wondering how you can get people involved at that level, and how you work with those people and to work to better animal lives.
Yeah, I mean, I think it's key to approach these topics as not a zero-sum game, not sort of either or, but finding overlapping interests. And we at the ASPCA tend to work in a lot of coalitions across sector. And so, for example, right now we're fighting a USDA proposal to reopen rulemaking around line speeds for poultry slaughter. We're potentially also looking next at seeing something come out around pig slaughter, again, increasing allowable line speeds, which obviously you can imagine poses a lot of direct threats to animals. These lines already run at just a rate that's practically blurring. You can't even see the animals flying past the inspectors. But for the most part, the folks in our coalition fighting that are not animal groups. We've got a lot of consumer safety groups involved. We have health groups. We have public transparency groups fighting. We have local groups. We have inspectors who've joined. And so that's really the key, I think, is each time one of these issues comes up, you figure out what are all the interests at stake, and you gather the stakeholders, and you make sure you understand the range of issues, and we find common ground. And of course, we haven't all identified precisely the same solutions in our bucket that we'd like to propose as alternatives, but there's always a sweet spot where there's that overlap, and that's very powerful.
Yeah, and I'll just add, I think it's important, that we have a broad coalition. I mean, you saw in my slides, I represent farmers as much as anything. Those are often clients for us, and what we try to do there is to show the court and to show the public through the education process that there are alternatives. As a movement, we have to make sure that we're not just against everything. We have to provide a better alternative to the American populace, to these local communities, and say, no, this is the way we should do this. It doesn't have to just be this industrial paradigm. There's a better paradigm. And I think we can improve there. I'm not sure what it is. Maybe we use regenerative agriculture. It needs a name, even, in my opinion. But we're getting there. We have to redefine that new vision for our food future.
Go ahead.
Okay. So I was just wondering, when pursuing litigation, if you have a general strategy for establishing standing in those cases.
I mean, it varies from case to case, and I think it depends, for our Ag-Gag cases, ALB Act is appointed because it would like to conduct undercover investigations that it can't. So we've suffered an injury. If it's a consumer protection case, it's someone who has been misled by the false advertising. So it kind of depends on the case. I mean, obviously, it would be much easier if farmed animals had standing on their behalf and we could address these issues directly. But given the specifics of Article 3 and state standing requirements, we have to sort of jump through hoops, and it's going to vary from case to case. Sometimes it's local communities that are affected by pollution, or any of the constituencies that we talked about who are affected. Those constituencies can usually have standing because of the injury they suffer from industrial animal agriculture.
We have time for one more quick question.
Well, then I'm really grateful. Hi, my name is Renee Marinkovich, and for this weekend you can consider me a fan and a lawyer groupie. I am not a lawyer, but I am here because I appreciate what all of you do. It isn't something I can do easily, but what I can do well is connect. So I'm on a mission. Over the last year and a half, I've been attending conferences and volunteering. And what I'm here to do at the end here is offer to you a connection. You're building a coalition. I happen to have met in New York a gentleman named Jeremy Collar, and he has created the FAIR Initiative. It is an initiative that aims to alert investors to the significant material impacts that factory farming could have on their portfolio. FAIRR. Follow the money. So Jeremy, in his brilliance, he's very successful in England, understood that he had in his phone all of the key investors in the world who invest in McDonald's and all of these different things. And it occurs to me, you are in a silo here of brilliance, of your ability to work with the law, right? A lever. And the more that the consumer and the business person can be connected with you, right? So I'm that person, and know there's more of us who are simply trying to connect your brilliance and what you're striving to do to the money and to the hearts of the consumers. So I'm just simply here as an advertisement. I'm not associated with them any other way, but Jeremy Collar and the FAIR Initiative, I think, is for you.
Thank you very much. And then I have one more final question from our live stream. How can we get access to your slides, Suzanne?
I believe slides are going to be posted by the conference online, so I will contribute my slides.
Wonderful.
Yeah.
Thank you all for joining us this morning, and thank you to our panelists. We have a 15-minute break, and then we will regroup at 10:45 for the next panel. Thank you.